FDP sessions. I now hand over the session to Dr. Sonal to proceed with the uh, next session.
Thank you so much, sir. So, again, good evening, everyone. And now we are proceeding to the second session for today's FDP. And it is my humble privilege to introduce the expert speaker for session 2 of today's FDP. Lipi ma'am, are you there in the meeting? Very good evening, ma'am. Very good evening.
Good evening. Good evening, all of you.
Good evening, madam.
So now I'll take a moment to introduce our distinguished speaker for today. Dr. Kumari Lipi is a patent, design, and trademark attorney with experience in advising, guiding, and mentoring various aspects of intellectual property rights to multiple business and industries in India. She is a member of the Bar Council, Delhi, and a practicing advocate in Delhi High Court, handling litigation matters in the field of IPR. She has been appointed as a registered facilitator for Startup India, recognized by the Government of India, Ministry of Commerce and Industries. Additionally, she is a NEPAM TFAC coordinator trainer, nominated by the Office of the Controller General Patents, Design and Trademarks, Bauddhik Sampada Bhavan to conduct IP awareness for NEPAM 2.0. She covers various aspects of IPR, including patents, trademarks, industrial designs, and copyrights in the global scenario. She worked as a Women Scientist C at Technology Information Forecasting and Assessment Council, a division of the Department of Science and Technology. She holds a PhD in Atmospheric Science from Birla Institute of Technology, Mesra, an MSc from Delhi University, and a BTech Pharma from AAID University, India. She published several SCI and Scopus research papers and conducted various workshops, webinars, and seminars. She is also the managing director and partner of Akhildev IPR and Research Services LLP. Ma'am, we are very delighted to have you in the panel of experts for this FDP. Ma'am, you can please share your screen and we'll check whether it is visible to the participants or not. And then you may start with the session.
Okay. Thank you. Thank you, Sonal, for my brief discussion. Is this visible, Sonal?
Yes, it is visible, ma'am. You can also do the full screen if it is possible at your end.
Yeah. Is this okay?
Yeah, this is fine, ma'am.
Yes, ma'am.
Okay. So good evening, all of you. I hope all are there.
Good evening, ma'am.
Good evening, ma'am. Good evening, ma'am.
Dear participants, please be connected. There was some network issue on ma'am's side. It will resume shortly.
Okay. Yes.
Yes, ma'am. Your screen is visible.
Yes, ma'am. It is visible now, ma'am.
Ma'am, I think you are muted. Lipi, ma'am, you can try to unmute yourself.
Am I audible now?
Yes, ma'am.
Yes,
Your
ma'am.
screen is visible and you are clearly audible.
Thank you. Thank you so much. इन्हीं और स्टार्टअप है किसी के पास कोई स्टार्टअप एनी काइंड ऑफ बिजनेस एलएलपी प्रोप्राइटरशिप और कुछ ऐसा किसी ने स्टार्ट किया है एनी पार्टिसिपेंट
Participants may please respond by at least raising their hand.
ओके नो इशू
Yes, ma'am. Two people have
ऑल
raised their hands.
by people someone has raised
Yes, ma'am.
okay
Two.
2 person oh great बहुत अच्छा है are you able to see my ppt
Yes, madam.
Yes, madam.
okay there are two kind of property we all know the tangible assets and intangible assets tangible assets are those assets जिनको हम खरीद सकते हैं जिनको हम रख सकते हैं टच कर सकते हैं इनटेंजिबल एसेट्स आर दोज एसेट्स जिसको हम जैसे आईपीआर इंटेलेक्चुअल प्रॉपर्टी राइट्स हो गया जिनको हम टच नहीं कर सकते बट इट इज एसेट्स तो कि हम अपने नाम पे ओनरशिप ले सकते हैं तो ये दोनों ही एसेट्स हमारे लिए बहुत इंपॉर्टेंट होते हैं अब जो टेंजिबल एसेट्स हैं उसके लिए क्या है आपको
Ma'am, sorry to interrupt you, but I think most of our participants are from South, so they find English
ओके
as a
मैम
better language.
okay thank you मैम
Okay, oh.
There are two kind of assets. First are tangible and or second the intangible assets. Tangible assets, those assets, those we can, you can touch those assets like car or your land or any kind of mobile. But intangible assets are those assets we cannot touch, but is more valuable like a tangible assets. Maintaining and protecting the intellectual property rights of a company. Company belongs to both assets, tangible and intangible assets. Like intellectual property right is also part of your company assets. So when you start your startups or any kind of company like proprietorship or partnership or LLP, that the first stage of your operation when you start or go to register your company to MCA sites or MCA websites or go to your CA. So it carry both kind of asset, tangible or intangible. When you go for when you think about that I am able to start my own business, I can start selling or buying something, exporting or any kind of idea that you think I am able to do business either alone or group of persons. So when you start your own one person, that is proprietorship. When you start with 2%, it is a partnership. When you start with more than 2 persons or private limited or it's a different type of company. So what is a startup? Startup is a tag. When you, it's a period of 7 years, you get certificate from DIPP or Startup India, apply for that. I have started with this year. So when you get certificate from DIPP as a startup, it gives you some advantage. Like when you file your patent in patent office, it will rebate 80% in your filing fee. Before startup certificate, when you file your patent in patent office, you have to pay 8,000 for filing fee. Now with startup certificate or MSME certificate, you have pay only 1,600. So there is a huge difference when you get your certificate from the DIPP. So government bear facilitation cost. many of the startup do not know how their certificate benefited to their company. So it is started by 2016, Government of India, for the fast track of patent application. Even it is not benefited when you file from outside India, international application, but India give you 80% rebate for your intellectual property rights. A startup obstacle. What is the main obstacle when you start your startups or company proprietorship or partnership? It is a lack of awareness. Which kind of legal issue it will come? Funding, capital, where you get the funding or capital, insufficient skill. You don't know how the file the ITR, Form 8, Form 3, or some legal compliances, lack of marketing strategy. You don't know how to get more client leads for your product or uh, whatever you want to sell. The startup have obligation to operate compliances. Yes, there are lots of compliances when you start your company, either proprietorship. When you think I will start my business from my own home house, so it is not easy without taking fire. You want to start your tiffin system from your home. So first you have to take the fire compliances, and there are lots of compliances when you start business from your home. Your neighbor is okay with that kind of complications. So it is not easy when you do not take those compliances, those certificate, or it will give trouble in a further year. When you grow up, it will give you trouble. So when you start, first you have to take complete knowledge of those compliances or those law. Even there is a different compliances in different state. Like UP has different compliances, Maharashtra has different compliances, even Kerala has different compliances to start their business at their from your home. So you have to first check all those compliances to start any kind of. There are like UP has a different land and different area. You cannot buy your company at any place. There are different fixed area. You have only purchased those area for your company, those land for your company. So different state has a different compliances. Non-compliances are unethical or ethical misconduct may lead to start up the serious trouble like fine, punishment, revocation of license, litigation expenses, which may cause an adverse effect on the limited capital of the startup. Yes, when you do not file your Form 3 or Form 8 or 11 at a limited time period, it will increase your fine year by year. You miss 3 years, it will come at like 1 lakh of fine on you. So it is a very complicated thing when you miss some form during your ITR year, financial year. So we will discuss further slides some most common legal and ethical issue which a startup face in India when we move forward to IPR issue. So same like you do not think the patent is very easy, or when you get your patent end of all compliances. No, when you get your patent certificate, it start with compliances. It give you some other compliances, other like filing form 27 every first. Previously, it has mandatory to file every year form 27 after getting patent. Now government has given some relaxation to form 27. Every 3 year you have to file form 27 after getting your patent. Every year you have mandatory to file renewal. You have to submit some other compliances to your patent. It doesn't mean you get your patent and end of the work. Uh, End of the all the complication has completed. So no, the legal issue when you start your company in the advertisement and marketing. Yes, advertisement, you cannot advertise anything anywhere or any websites without any permission. Sometime copyright issue will happen when you take some photographs on some voice of other uh, like Amitabh Bachchan voice, you cannot use in your advertisement. You cannot use other marketing or trademark marks in your marketing strategy. So these are some intellectual property right issue while your advertisement and marketing of your company. There are other different compliances also, like marketing. You cannot use same domain, or there are lots of litigation matter. Without knowing those tricks or those small compliances or a small उसको क्या बोलेंगे स्मॉल स्मॉल जो उनके डाउट्स होते हैं एडवर्टाइजमेंट के, यू कैन नॉट यूज दोज थिंग्स। कोई भी आप यूज नहीं कर, यू कैन नॉट यूज दोज पिक्चर्स, और इवन लाइक शादी.com, और देयर इज अदर डोमेन नेम इज Sadi.com. There is and litigation matter is going on both domain names. So even very similar kind of trademark here give you some trouble. So business structure is issue, licensing permit issue, dealing with the passing. If you do not have trademark certificate and you want to stop other to giving other to stop their businesses to using your trademark. So it is a come under the passing of infringement, counterfeiting goods. So these are different terms when you have a trademark, when you do not have trademark certificate. So infrastructure related, their local law, data protection, copyright and privacy law, renewal and protection of intellectual property rights. When you get your trademark certificate, it only 10 up to 10 years. After 10 years, you have to renew those trademark certificate. Copyright has a up to 60 year. And even when you get your trademark certificate, it doesn't mean you is sufficient to get stop other of infringement. You have to take TMC, trademark certificate, and even there is different class. It doesn't mean you have you started your business in a medicine and you have a trademark in class 5 and it is sufficient for you. No, you have to take one more certificate in class 35 for online businesses. So if nitty and gritty, there are lots of things. So you have to take some, first you have note down all those things and get some expert advice in their field, like intellectual property or marketing or licensing. So every person has their own expertise. Employee management, yes, employ like you have to follow the labor law. When you employ something or you have a factory, so you cannot neglect labor law, tortious liability. So different kind of liability you have to carry on while the startups or your company. Ethical issue, yes. Responsibility toward the customer, yes. You have to mention the term and condition in your package, and list of ingredients that use while you preparing your product. So this is all your responsibility. Responsibility toward the employee. So with kind of time period, 8 hours, 6 hour lunch period, and the training period, all you have to first non-disclosure agreement with your client, termination period. So all these legal term and condition you have to follow while during employment period of your employee. Responsibility toward the environment, yes, where you have started your company in a forest area, in a village, or in some different environment. You have, when you start different kind of environment, there are different issue. uh, you have to first take care of that. You cannot deal everything. Every environment has a same legal issue with same every environment. Like you cannot use land, farmer land for your company. You cannot started big businesses or any such chemical product at a society area. So these are different ethical or compliances matter when you buy your when you buy land or you start your company. Obligation toward the startup, obligation toward the community, concern with the respect of labor law. Yes, it is a very much matter when you start a factory of any kind of product. Labor law very much important for those factory because it is a very strong law, and any labor can make complaint about your time period or any like employment agreement, if you are not draft strongly, use of deceptive or inappropriate symbol and marks, it is a very much important. You cannot start start your business with any name, like maybe if you think it is a very noble term, or it is your son name or your mother name, your grandfather name, it is a unique for you. You cannot start with those names. Maybe it is already in a public domain, or somebody already started, or somebody has taken their trademark on those names. So it will give you trouble. So first you have to make it clear it is not available, or it has it not with other person. So licensing and legal issue also with the licensing and permit issue require various permit, udyog Aadhaar registration, import export code, FSSI license, GST registration. When you start business when you start business and earn more than 20 lakhs, it will give you compliances with the GST registration. Without GST registration, you face lots of trouble when your income company network more than 20 lakh in financial year. Many startup face legal issue, legal awareness, lack of legal awareness, and local law, as we discussed. Infrastructure related, their local law, as I discussed, office space and property for company construction, warehouse, service center. You cannot start with anywhere. When a startup plan to business from his residence, he may require take necessary permission from the local municipal authority, town planning authority, landlord. If the property is used by a tenant, you have to first take NOC from your owner. When a residential property is being used for commercial purpose, the property tax also changes. Even your electricity bill will also change when you start business from your house. First you have to pay. Previously you have to make payment as a uh, mm, commercial, not residential, as a residential property. After starting business, your mm, Bijli bill have electricity bill have to pay according to commercial property. So you have to take care of all these things. Data protection and privacy issue. Startups should avoid the access of private detail or user without their permission. It is very important when you use some data, or you can cannot draft some user detail, or like when someone visit to website and there is you have written, fill the form and you use those details, so must have mentioned their term and condition. You can use those details. Without permission you cannot use their detail in a publicly or marketing purpose. Ask the permission which are not related to their website or application. The startup should not use with the privacy of the user. Privacy statement should be drafted in a short, simple, and summarized manner. You cannot draft in 3 pages, 4 pages, or 5 pages in a legal language, because the normal person cannot read legal language, and 2 to 3 pages PDF. All are unable to understand what does that matter. So you have to first, it is a liability on you to draft the simple, short, and summarized manner. The privacy statement should be regional language. So, like if you started your business in Kerala, that the language should be a regional language. When you start your business in West Bengal, your language in a Bengali. When you start in UP, must be in Hindi and English also. So it's a different term and condition with the different state. Privacy policy, privacy policy and their term and conditions. A startup should also enter into an agreement with their user that they will not share, use the person detail. The user in turn will help the startup itself in gaining goodwill and trust of the people. So all these are liability on startups. Employee management, yes, an agreement enforceable by law is known as contract. Agreement with co-founder, yes, there are a lot of agreement when you start asking or you getting something from your client. So you have a non-disclosure with your client. You cannot use those information for your own purpose, or you cannot transfer those person to other person. So agreement should be with your client as a non-disclosure. Agreement should be co-founded, confidentially contract with the service provider, employment contract should be there. So all these on upon the company persons. And it is a tortious liability, it is a different kind of liability. And the protection of intellectual property right, it is the most important thing when you start your business. Patent, when you file patent on your name, so it doesn't mean it is belong to your company. When your intellectual property with your apply for as an applicant as your company, it doesn't mean that intellectual property is your. So when you make applicant your company, it belong to your company. When it on your name, that is you are owner. So both are different. It is okay you are owner of that company, but it doesn't mean you are owner of your intellectual property rights when you file on the name of company. Both are different things. Both applicant has different right. Inventor is different right. Applicant has different right. Same as the copyright case. You if are you owner or author? Trademark case. It is only on the company name, but sometimes people take their trademark on their name. So first you have to transfer those name to your company. Only that case your company will use those trademark. Same as the design patent. Design patent, there is no inventor, there is no author, only their applicant name. When you file your design patent, design registration, it's all are applicant. There's no other like a patent or copyright or trademark. There is only one who is the owner. Trade secret, there is no fixed law. There is no any law in India, but you can draft as a confidentiality agreement as a trade secret. So intellectual property right is the creation of mind. When you create something for your company, now and you file your application as a company as an applicant, so you are inventor for those intellectual property. So who is what is the invention, design, literary? There are lots of things like invention, design, literary work, symbol, name, and use in commerce. We will discuss in detail. So what will go for the invention, what will go for the design, and what will go for the literary and artistic work, what is the symbol, where it will go. There are lots of things of a company property. So when you invent something, when you create use of technology, when you create some products, so it doesn't mean it all go for the trademark, all go for the patent. There are different there are 6 kind of intellectual property, mainly 4 types: patent, design, copyright, and trademark. So first you identify which kind of intellectual property need to get protection in which category. Patent we will discuss in detail further. Intellectual property right are granted through the law. Yes, when you invent something novel and have some potent inventive step. Yes, here it is. When a problem, you can understand like this. A problem can be solved through using a product, apparatus, composition, tool, process, method, or machine or device. All will go for patent. Either it is product, apparatus, composition, tool, process, method, machine, or device. The solution using the invention can be protected under the law. When you solve some problem through the design, outer appearance, you have a business of sofa and cutlery or chair, sofa sets and like some device. So when you change some appearance, outer appearance, and you use solve some problem, when you make a blade of fan instead of 3, 4, 5, so you change the design of the fan, so it doesn't go patent, it will go for the design protection. The problem can be solved by through a noble business startup. When you start like directing a movie and you solve problem through the creating some video, or writing some novel story, or some song, or started lyrics, so all those comes under the protection of copyright. And when you solve your problem through the business, like slogan, some device mark, some mm, service mark, it's come under the trademark. And as we discussed, literary comes under the copyright, computer program, artistic works, all under the architecture or advertisements, all under the copyrights. Yes, which kind of things are come under the patent? As we discussed, it is an exclusive right for the product, apparatus, composition, tool, machine, device, process. When you develop some process, so it goes to patent protection. It is up to 20 years, and it is a long process to get your patent protection. It is not easily available. First, you have to prepare your draft with a different form, and you have to file in patent office, and then it will get published, then for examination, then the first examination report, hearing, and lastly you get the grant certificate. Even after getting the grant certificate, you have liability to get commercialized, technology transfer, or filling the renewal fee every year, and filing form 27. There is different liability with you. So kind of tech subject invention is patentable. You think, is this human necessity is patentable? Yes, human necessity, any kind of invention belong to human necessity is all are patentable. Performing operation, yes, it come under the patentable. Chemistry, metallurgy, textile, paper, fixed construction, mechanical engineering, lighting, heating, weapon, blasting, physics, electricity, all come under the patentable subject matter. It all are patentable. So why I'm here written first human necessity in a different ABCD manner? Because it belong to class. There are 8 class. When you search something related to human necessity in a Google patent search, advanced Google patent search, or in pass, you have to come under the your invention come under the class A. And when something related to performing operation, transporting, when you invent something related to this, you have to search in class B. So there are 8 class, and invention belong to different class. While you get to know is this in public domain or not, first you get the patentability search report, either yourself or from expert site. So these are the class. When you search randomly in the Google patent search, USPTO or ESpaceNet, it give you lots of results. 2 lakhs report, 2 lakh patent. But when you search through the classification, it will give you 1,000, 1,500. So easy to check out those patents when you go for search through the classification. That's why I mentioned as per the classification. So kind of subject invention is not patentable. When you started thinking about the dramatic work, musical, artistic work, and go for the filing of patent, it is just wastage of your time, your money, and it is not under the patentable matter, under the section 3 of Patent Act 1970. So all those are come under the copyright. It is not under the Patent Act. So kind of subject matter not patentable. Yes, again, when you mix two things, or presentation of information, topography, which affect traditional knowledge like Dadi Nani, Nukse. It is not under the patentable subject matter. Even the method of playing game, it is not under the patentable subject matter. When you started thinking it is our business method, sometimes people come to me and tell it is my business method. Please make it file the patent and I need grant certificate. No, it is not come under the patent. It is a maybe it come under the copyright matter, but it is not patentable matter. So you know you should have knowledge about those which are not under the patentable subject matter. And who can file the patent application? Yes, it's written in the section 6 and 134 of in Patent Act 1970. Can be either alone or jointly. If you want, both you and your company want to become a applicant, yes, this possible. This is possible. You can file as an applicant of your company with along with you. Both can be applicant by any person claiming to be true and first inventor. Anyone can file the applications when he or she claim true and first inventor. Any person being assignee of the person claiming to be true and first inventor with the proof of assignment. Any legal representative of deceased person, someone died before filing the patent application. So the legal representative can file behalf of those person of or assignee will file those patent application behalf of that person. Where to file patent applications? Yes, there it is a territorial limit, comes under the territory. If you belong Chennai, or you belong to Tamil Nadu, Kerala or Goa side, that it will come under the Chennai office. When you come from the north side, like Jammu and Kashmir, Haryana, Punjab, your office will be Delhi office. When you belong to Gujarat, Ahmedabad, and there are 4 different offices according to your residential or domicile, like Chennai office, Delhi office, Mumbai office, and Kolkata office. So there are when you file, you live in Chennai or you file your application in Delhi office, it will not acceptable. Your application will transfer either automatically or by your applications. Other it will delay. It will delay your patent grant certificate if you do not have knowledge where you have to file your application according to your domicile. It is a territorial patent has territorial right. If you get grant certificate in your country, even India, it doesn't mean you have a right to do business outside India. It is a territorial right. India has their own patent act. US has their own patent acts. So you have to get grant certificate in US when you want to protect, when you stop someone to do business that patentable thing in US. So it doesn't mean you have a patent certificate in India, you have a right to stop all over the world to person to do the businesses. So if the applicant has no business domicile in India, if you belong to China and you want to file in India, so you do not have any address in India, so the address service of your agent will be the your address. And yes, the Chennai belong to state of Andhra Pradesh, Karnataka, Tamil Nadu, Union Territory, Pondicherry, Lakshadweep, and Mumbai office domicile of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chandigarh, Union Territory of Daman Diu, Dadar Nagar Haveli, New Delhi belong to Haryana, Uttar Pradesh, Kolkata. File a patent application. Document can be filed in patent application either online. Physically, you can also file. Nowadays, it is mandatory to file the online. You can contact the patent agent if you are not expert, so you can contact expert well qualified for your patent application. Otherwise, you lost the actual claim of your invention. And we all aware about the grant or the stage, different stages of patent, getting patent. Mm. Should I explain these things? Maybe all be aware about those, how much cost of patent application and what will be the cost of examination. Hello? Hello? Am I audible?
Hello. Yes, ma'am.
Yes,
Ma'am,
ma'am,
I
you're
think we
audible,
can
ma'am.
briefly go through it because some of them are interested, I think.
Okay. So these are the basic common stage for the patent grant. First, you have to file either provisional or complete specification. Provisional means you do not have completed your research. Like when you start your PhD research, when you enroll in PhD, or when you start your company, both are different. But when you have not completed your research, when you start your company, you have some idea, some process you opt by own. So first you have to get uh, protection of your invention as a provisional applications. And when you completed or file the complete specification, so it is as a complete specification. But both when you file provisional, you have a 12-month file to file the complete specification. After 12th month, it will get abandoned. So it is a very specific time period. We have to remember after provisional filing. The publication, when you file complete specification, it will automatically get published after 18 months without any fee. But you want your publication in within a month, so you have to file Form 9 with the early publication form, which is Form 9. After filing the Form 9, you will get your application within a month. It will get published. So it will cost you extra 2,500. Otherwise, it will automatically get published after 18 months. After publication, you have to file request of examination. Previously, it was 48 months. Now it is a 31 month. So after request of examination, your examination will start. You do not think it will automatically start your examination after filing your patent application. No, uh, there is no any provision automatic examination. You have to file your examination form via for form 18 with the certain 4,000 fee. When you file expedited examination, there is a 8,000 fee. And after filing examination, your examination will start section 12, 13, 14, 15, and they will issue the examination report on your for your invention. There are list of objection according to Patent Act. There are list of objection on your novelty part. There are different objection on your inventive steps. It is a novel or not, it is an inventive step, there is a lacking of inventive step in your claim, and it is not patentable under the Patent Act Section 3. So there are different kind of objection they will issue on based on your invention. And after giving reply, preparing those reply and submit to patent office, there is only 6 month time to submit those reply to patent office. You will get the patent certificate directly, or in some cases they will issue the hearing for the other some objection over uh, those according to Patent Act. There are some objection over the Section 3, mostly Section 3 or inventive step. Sometime it prior art, sometime controller asks for the model. It is a video. In a video you have a completed, or you have a, like, you prepared some cycle or motorcycle, different kind of motorcycle or cycle. A controller want to see, is this feasible? You have prepared, you have a prepared your invention in a physical form. Can you show me video or real model? So it is a different kind of objection they will issue. And after getting the grant certificate, there is a two type of opposition. First, pre-grant opposition and post-grant opposition. What is the pre-grant opposition? Pre-grant opposition, before getting the grant of your patent, you can file, anyone can file pre-grant opposition for your application. Sometime it will file by the competitor, sometime it will file by those person who has some rights in your invention, but you have not mentioned those person name in your invention. What is the post grant opposition? You have even you have 12-month time when your name has been not mentioned in some patent application, and you deserve the name of those application. You have a time to 12 months after getting the grant certificate. And even appellate board, now the appellate boards had dismissed or dissolved. There is, you can directly go for the after if you do not get favorable decision on your name after filing the post grant opposition. So you have right to go for the high court or regional state high court or direct Delhi high court against those decision of controller. Document required for the filing of patent application. Yes, when you go for the physical filing, so you have to prepare the covering letter. But nowadays, all application will file through the online application, so there is no required of covering letter. But before, in previous stage, first you have to prepare the covering letter with the list of document to your name, and nowadays it is not mandatory. Application of grant or patent form. Yes, form 1 is compulsory. It is a mandatory with your fee, 1600. If you want to know more about the form 1, you can see section 754, 135, rule 20 of Patent Act. What is a form 1? Form 1 is a detail regarding the who is the applicant, who is the invention, title of the invention, who is the patent agent, name of the all inventor with their addresses, and who is the true and first inventor, your application is complete or not, how many claims are there. All description are mentioned in a form 1. So form 1 is a mandatory. Without incomplete, form 1 cannot hurdle you to get publication of your patent application. So it is a mandatory to fill form 1 with very minutely with the complete information. And the third part is a complete or provisional specification with the form 2. Form 2 is also mandatory, and you want to more detail about the form 2 is mentioned in Patent Act section 10 and rule 13. Form 2, what is form 2? It is like your paper, but no, it is not your research paper, kind of research paper, but it's just like a application. Form 2 is there. First you have to title and the background, summary, abstract, and the brief description of drawing as per the mix of Patent Act. Not like your paper, simply paper. There's a techno-legal document. Techno-legal document with the technology, with the legal term. So it is a complete specification. The fourth point is a statement undertaking in Form 3. Form 3 is a statement undertaking, means you are filing in India or outside India. You have taken FLL, foreign filing license, or you are coming, you want to file outside India without filing in India. There is different provision. So a statement undertaking through the Form 3 is a statement you are directly filing in India without filing outside India, or so you have to mention these things. Okay, what, how you proceed. It is ordinary application or conventional or PCT application. So it required more information in Form 3. The Form 5 is, point 5 is power of attorney. When you file your by own, you want to file your patent application by own, there is no requirement of power of attorney, but when you take help from the patent attorney, so you have to file Form 26. Form 26 is mandatory because that need your sign on behalf to file those patent application by the patent attorney. Declaration of inventorship in Form 5. only in case of Indian application. Yes, declaration. What is declaration of inventorship? You are there are 5 inventors. So it is different, separately declared by through the form 5. Yes, we have declared, I have declared, all those are inventor in my application, patent application. Applicant will declare with their name and their addresses, with the nationality. It is from India or outside India. Anyone can file, even outside India person can file in India patent application as an inventor. The certified true copy of priority document. If you filed, your application has been filed in India through the PCT application. So there is a priority document required. Requisite fee, yes. Industrial design. What is industrial design? Industrial design is the outer appearance design. It is industrial design does not require inventive step. It is industrial design require only the novelty. There is no requirement. It is very easy to get because there is only 2 or 3 months you will get your design certificate from the patent office, because it is a very easy process due to novel part only. Kind of product of industrial design protection, yes, handicraft item, household item, lighting equipment, jewelry, electronic devices, textile, industrial item, all those belong to industrial design. And the patent filing outside India is with the different time limit, like PCT filing. PCT filing, if you file your application in India, if you and you have desire to file your application outside India also, so you have only 12-month time to file your PCT application. After 12 months, you cannot file your application outside India. So it is a very big thing. When you start your businesses in India and you have a desire to, you have a wish to make it make your company international, so you have to file your application also outside India through the PCT or conventional method. Both have a 12-month time, and 6 month 16-month to ISR or written opinion. When you choose while filing outside patent application outside India, you have right, you have option to choose India as a search authority. It will give you extra advantage. It will expedite your examination in India also. 18-month international publication. When you file application while through the PCT application, you will get international publication. Your application will publish in WIPO after 18 months. So all over the world can see your company has started in those company has started doing business in this domain with the research or with the patent. Easily you can recognize by all over the world. And 22-month optional file demand of IPP, and 18-month is a different. It is a other country filing date, like a 30 to 31, 32-month. When you file PCT application, directly you can file your application 158 country. But when you but you want to your patent grant certificate in US, it doesn't mean that filing the PCT application will give you the grant certificate in US. After filing PCT application, you have 30 to 31 month, 32 month to start your procedure in US, Germany, or China. There are different territorial procedural part to get the certificate in those countries. And the patent database, e-commerce platform, patented product monetizing, yes, the relevant company you can directly contact. And these are the educational and always help desk. You can search here and the supporting document. Any question from your side?
Good evening, ma'am.
Good evening. Oh, my camera
Ma'am,
was off.
as you're talking about the ethical and legal issue, my question is
Legal issue.
what's the one legal mistake or mistakes you see founders make most often, and how do we avoid it?
Yes. There are different, but I want to mention one is a agreement. Agreement like what kind of percentage with your co-founder must be with the legal agreement. When you get
Oh,
trademark certificate or patent certificate on your name or on your company name, so after some time it will dissolve or it will bind up as a company. So who will get the ownership of that trademark or that patent? So must be mentioned in a writing way, in writing manner with the agreement. It is a common mistake when more than one person started their company, and without mentioning all the ownership of their company, like LLP or partnership, but not in writing way, not in writing manner. You haven't mentioned the 60% or 40% and who will own after dissolving your company, uh, trademark or patent or copyright or intangible property. So you must be also aware about the intangible property right of your company.
okay, ma'am. Ma'am, one more question. When should a founder first hire a lawyer?
From the first day before
Okay, ma'am.
starting the company, first you have to work with your advocate or lawyer or expert. So how the legal matter will dissolve if we face in any kind of legal matter, either tangible property or intangible property or compliances or legal matter. When you start your business from your home or you want to establish your company, you want to rent, you want to start your company as with the rent agreement. So there is a different legal matter. When your owner not giving the NOC, it will give you hamper in later coming days.
Okay, ma'am. Thank you, ma'am.
Ma'am, good evening, ma'am.
Good evening.
My name is Naresh.
Yes,
Ma'am,
Naresh.
yeah, if I at the time of purchasing a patent rights in the
Purchase.
agreement, uh, means if the time of filing the patent rights means I innovated a product and I filed the patent rights, but at the time of filing the patent rights, at the time of specifications, in the specification, one item means one exact so many innovations is there in the one product. At the time of filing the patent, uh, all the specifications I did mention. So, but after that here, a purchase means the patent rights are received, but another competitors they identified that in that particular product, another specification also there, and based on that, again he filed the patent rights by using what I unable to mention at the time of filing the patent, right? That specification will be mentioned by a competitor, and they will be taken a patent grant. At that time, what I need to do that?
Yeah, a very good question. It is not possible when you get grant certificate on some specific thing or your claim, and someone else again file the same claim in patent office and get the grant certificate. It sometimes it looks it is a very similar, but it is not similar. Some you have to first go with the patent attorney or a patent agent and compare those claims. If it is very similar to your patent application, you have right to file the post grant opposition. You directly challenge the patent grant certificate, and you for invalidity search, and you can abandon those. You can challenge those patent certificate. It is not possible either. if it has improvement to 30 to 20 to 30% is not possible to get grant certificate. Yes, even 30%, but sometime it improvement more than 30% or 50, 40, 50%, there is chance to get grant certificate, but it is not possible to easy. It is not easy to get the grant certificate by patent office. In those cases, you first consult the patent attorney and ask for the comparative analysis of both claims. Is there possibility to both are similar? You directly file the invalidity of those that patent.
Um, at the time of filing the patent, in a graph mode, in a diagram mode, the document also attached at the time of filing the patent. But one specification I didn't highlight it, and that one specification related diagram, this visible appearance related document I didn't attach. But another person, my competitor, is attached that another specification, means what I missed that specification. By attaching that specification in a document mode, they taken the patent rights.
Yes, yes. Is this possible? When you mistake something, like most of the academic person of India file directly in patent office without taking help of good patent attorney, without drafted the boundary of their invention and file in patent office. Some of the Chinese industries, some of the Chinese company who has taken watch facility, patent watch. When you file your patent, and it visible to all over the world. You are working in a biotechnology, and I have a patent watch in biotechnology. You just after filing the patent application, I can easily see, yeah, yes, you have filed this patent related to biotechnology. Oh, yes, you have mistaken these things. You have not mentioned these things. So it is not grantable in India. It is not possible to get grant certificate while those mistakes. Now I have right. I have option to improve those things, add those things, and file in patent office with those extra things. So it improve those novelty, it improve those inventive steps, and it gives the right to that person to get the grant certificate. But you have not mentioned those part, or you have a missing part. It will come under the first examination report. I will not even to give reply properly. It will hamper your patent, or you're not able to get the grant certificate. So it is a mistake. Most of the person did those mistakes.
Ma'am,
Yes,
if I maybe at the time of filing the patent, the innovative related, the visible in the graph mode, the attached, all the documents are attached, but the patent right, I would be purchased only the limited area in India only. At the time of filing the patent, I selected within the India,
right.
but in another country, by using the data, they would be copied, and another country they purchase another, means they file the patent, and they will be taken the patent rights. Uh, First, I filed the patent rights. At the time of filing the patent rights, the innovator related all the attachments in a display mode, in a graph mode, and all the specification I mentioned. But due to some reasons, at the time of filing the patent, I selected only the India only. But another person, by using the data, they would be file the patent in USA. means that is a copied or any legal production
Yeah,
can it take?
there's two different case. When you file your patent application in India or any country with documents, details, it that come in public domain. Even it does not grant in India, but when you file in US, it doesn't mean you will get the grant because your novelty is already in a public domain. You cannot get grant certificate over those specification which is not filed in US, filed in India, it cannot be grantable in US. Even any country, 158 country cannot grant certificate over those specification that file in India. Yes, the second thing is when you file your patent specification in India, it can be improved, it can be novelized, some adding part or improved version can file in anywhere, even in India, is grantable. But those application which file in India, it doesn't mean it can be patentable outside India. No, it is not possible because it is already in public domain, and there are three most important criteria to get the patent. Is first one is novelty, and in novelty is not available for those for your application, so it is not grantable anywhere in the world.
Okay, ma'am. Thank you, ma'am. Thank you, ma'am.
Thank you.
Hello, ma'am.
Yes.
I have also a doubt.
Yeah.
Everyone talks about filing a patent, but ma'am, my doubt is it better to keep some parts of my work or process as a trade secret rather than patenting it? I heard that if I patent it, I have to reveal exactly how it works to the public, which might actually help my competitors and somebody else. Like, ma'am, I have heard
Mm.
that Coca-Cola's recipe is a trade secret, not a patent. I have heard, ma'am.
Yeah, right. You are right. Yeah, Coca-Cola recipe a trade secret because patent life
Exactly.
has only 20 years, but the trade secret has endless life. But protection of trade secret is a very difficult, and India has no law for the trade secret yet till date. So
Okay, ma'am.
outside India, US has a trade secret law. When you want trade secret of your recipe or any kind of use or business method, so when you share with someone, you must protect it under the non-disclosure agreement or some kind of agreement. Without agreement, when you share something, it is not under the trade secret.
Okay, ma'am.
It is not protected.
Okay, ma'am. Thank you, ma'am.
Thank you. Any other question? Or you can directly mail me if you face some trouble or any legal or unethical issue. So my mail ID lipi.condila@gmail.com or lipi@iprsrg.com. Yes,
Participants,
Sunani.
if you have any further question, you can unmute yourself and ask the question. I think participants are really charged up. They are so inquisitive to ask you about so many patents, trade secrets, etc. If there are no further questions, I request all the participants to please switch on their cameras. We'll take a moment to have screen shared with Lipi ma'am. Participants, please switch on your cameras.
सीरीज एक से बराबर प्रतिनिधि लेकिन विशाखापट्टनम में भारतीय द्रोह
Deepak sir, you are requested to please mute yourself. Gradually, many participants are joining for this screen sharing. So,
Sonal ma'am.
hello.
Hello ma'am. Done.
Thank you so much, ma'am, and thank you all the participants. I mean, everyone was alert during the session, and it was great interacting with you, ma'am. So thank you so much, ma'am, for the highly informative session on intellectual property rights. And in my perspective, your insights help all of us to understand the significance of protecting innovation and the practical aspects of patents, copyrights, and trademarks. And more so, the real world examples and clarity and explanation made the session very engaging. So again, thank you so much, Lipi Madam, for your session
Thank you.
and your valuable time.
Thank you. Thank you so much. Good night.
And our participants
Thank you.
can switch off their
Thank you, dear
cameras.
participants.
Thank you, ma'am.
Participants, we will again resume tomorrow at 6 p.m. Tomorrow there are two sessions scheduled. One from
Okay,
6
sir.
p.m. to 7:30, and the second session will be from 7:30 to 9. So the same link will be applicable for tomorrow's session as well. Thank you and good night for today. We will resume
Sir.
tomorrow.
Thank you, sir.
Good night, sir.
Good night, sir.
Thank you.
Good night, sir. Good night, sir. Good night, sir.